to this third installment of Soundbites. My name is Stephen Ragan, and I am the Principal Privacy Consultant and Subject Matter Expert on Privacy and Data Protection at Wrangu. With these Soundbites, I talk about recent and relevant topics in the areas of privacy and data protection. Today, I will be talking about three distinct areas. I will start with Virginia and their passing of the Consumer Data Protection Act. Before I turn to a little more theoretical discussion on the tensions between security and privacy, in particular exploring the UK context and the Investigatory Powers Act of 2016, and how it's being deployed in the context of creating online dossiers and internet connection records. Before turning finally to Europe's surveillance and intelligence services, and how the member states aim to avoid the decisions of the Court of Justice of the European Union, particularly in this area of national security. So I'm going to get right into it and start with Virginia. On March 2nd, 2021, Governor Ralph Northam signed the Consumer Data Protection Act, the CDPA, making it the second comprehensive piece of privacy legislation after California. Though this often overlooks actually Nevada and Maine, who have their own forms of privacy legislation. And there are kind of different contexts in America for dealing with privacy and data protection. Often this legislation is sectoral. So for instance, there is HIPAA, which governs health information, as well as Gramm-Leach-Bliley, which regulates financial information. So there are definitely a lot. There are a lot of forms of privacy legislation in the United States. This privacy bill, this privacy act, is definitely being framed though as the second comprehensive piece of privacy legislation. And of course, as we look to the future and whether or not we'll get a piece of federal privacy legislation, there's an interesting little tidbit that some people in the privacy community on Twitter conducted a poll asking the question of when we would get federal privacy legislation. And it seemed like the critical mass was about 5 states with privacy legislation. Obviously, these are just guesses, and so we will have to just wait and see. I will discuss a bit about the CDPA and its comparisons with the GDPR and the CCPA, where there are definitely crossovers. So the scope of the Virginia law is very similar to the CCPA, looking at privacy in the context of the individual as a consumer. So again, the standards are for businesses or entities, and the threshold in Virginia is a little higher than in California. So the Virginia law will apply to entities either controlling or processing the personal data of 100,000 consumers. This doubles the CCPA requirement, and it will control, or the entity controls or processes personal data for at least 25,000 consumers and derives 50% of their gross revenue from the sale of personal data. So notably, absent is a revenue threshold, as in the California Consumer Privacy Act. That means that even larger businesses who don't meet these two particular prongs of this threshold may well be excluded from enforcement of the legislation. There is one point I neglected to mention at the beginning. The Consumer Data Protection Act will come into enforcement on January 1st, 2023. That's the same time as the California Privacy Rights Act. The update to the CCPA will also come into enforcement. So there are some specific exclusions from the definitions of personal data under the Virginia Act, particularly de-identified or publicly available information is excluded. And the definition of consumer is defined as a natural person who is a resident of the Commonwealth acting only in an individual or household context, specifically omitting a person acting in their commercial or in employment context. So that's a really important distinction to make about the American approach to privacy, particularly looking at the individual as a consumer. Whereas in Europe, it's the natural or legal person um, in its entirety, not constrained to this particular context, again, of looking, as they do in America, at the individual as a consumer, importantly excluding, for instance, employment information from regulation under this new Virginia law. So another really interesting exclusion under this Virginia law is, in particular, if so privacy in America is very often done sectorally. So for instance, there is a piece of legislation for financial information under the Gramm-Leach-Bliley Act, and then there, for example, is another piece of information for health information, which is governed by the what's called HIPAA, the Health Insurance Portability and Accountability Act. So for organizations or entities actually that collect financial or health-related data, in Virginia, the regulation will fall completely under the Gramm-Leach-Bliley Act for financial data, again, or under the HIPAA for health information. So that would mean that organizations are completely exempt if they collect financial or health information, even when that information does not relate to finances or the individual's health, which is a really large opt-out, or excuse me, a really large exclusion for organizations, and a nice little carve out for businesses. So there are similarities again with the GDPR and the CCPA. The Virginia law provides data subject rights, and these are basically taken from the GDPR. We have the right to access, the right to correct, the right to delete, the right to data portability, and the right to opt out of processing. Something new that's included here is what's called the right to appeal, which is included for instances when organizations or entities decide that they do not want to grant the data subject, for instance, the right to access. So the individual then has the right to appeal such a decision. Like the CCPA, the CDPA provides businesses 45 days to respond to data subject requests, whereas in the GDPR, that is 30 days. A few more interesting inclusions under the Virginia law that cross over with the GDPR. In particular, there are data protection assessments, much like the data protection impact assessments under the GDPR, as well as requirements for data processing agreements, meaning when information is shared between controllers and processors, there will have to be a contractual agreement in place in order for that to happen. Notably, the CDPA lacks a private right of action, meaning all enforcements and investigations will be done by the Attorney General. This is different, definitely, from the GDPR, which includes a private right of action. Under the Virginia law, there is also an inclusion of a 30-day cure period. So when a violation is found, the Attorney General will notify the organization, and they will have 30 days to fix that issue. If there is a failure, to stop that activity, then the Attorney General can issue fines up to $7,500 per violation. So this is the Virginia law. This is the Consumer Data Protection Act, something to look forward to in the United States as more and more states begin to adopt their own pieces of privacy legislation. So again, we had California 2 years ago. They really got 2018, now almost 3 years ago. They really got the ball rolling on the issues of privacy and data protection. Virginia is the second state to enact their own piece of legislation, and there are a number of other states who are working on legislation and having legislation make its way through the process. So definitely one to look out for is like Washington. The Washington Privacy Act is actually in its third iteration, and is halfway to being enacted in its entirety. And there are other states as well, like Oklahoma and New York, for example, who are also debating their own pieces of legislation. As I mentioned earlier, in America, there's kind of a sectoral regulation at the moment of privacy and data protection. So again, as I mentioned, there are regulations for the financial sector, there are regulations for the health sector. There are also other interesting pieces of state legislation that are really having an impact that aren't as comprehensive as maybe definitely not as comprehensive as the GDPR or these pieces of state legislation, but are definitely used to preserve privacy. In particular, I'll mention the Bioinformation Protection Act in Illinois that was recently used to bring a case against Facebook. The case was recently decided, and Facebook was fined $650 million. That's a class action enforcement, and so each person will get around $345. And this again highlights a really interesting aspect of this enforcement provision. So again, as I mentioned, in Virginia, there is no private right of action, whereas under this Illinois law, for example, there was a private right of action, or there is a private right of action under the GDPR. Now you might notice that $345, that's not really a lot. And so that's one of the reasons that it's important to know how these cases are brought, in particular these class actions. And these aren't something new. These have definitely been utilized in the European context as well. When we think of the British Airways class action suit that's actually ongoing at the moment. So yeah, again, it's really interesting to look at the ways in which these privacy and data protection rights are sought and pursued in court, because $350 is not enough money to incentivize an individual to bring their own case. The cost of litigation will be far higher than $350. And so again, class actions are a really interesting case in which lots of individuals harmed in a little, I don't want to say a little way, but a minimally compensatable way, can join together and effectuate change at the level of $650 million. That's definitely a significant amount, even for big tech companies like Facebook. And again, so this enforcement action really facilitates a way to bring about ensuring that these privacy and data protection rights not only become law, but then are enforced for those underlying principles and purposes. And so now I'm going to turn to a bit of a theoretical discussion, perhaps on the tension between security and privacy, but I'm going to look at a practical example ongoing at the moment in the UK. And this in particular relates to the Investigatory Powers Act of 2016 and tests that are currently being conducted by the Home Office and the National Crime Agency, particularly utilizing the creation of internet connection records. So at the moment, there are two tests being run on the creation of these internet connection records, and these records are basically contain the metadata about your online life. And the law requires web and phone companies to store browsing history for 12 months. Although in order for law enforcement and national security to gain access to that information, they must have an approved order from a judge, similar to a warrant requirement. So again, this focuses on metadata. These internet connection records focus on metadata, which means that for instance, if you send a message to another online, the content of that information will be shielded. That cannot be accessed. But metadata tells a really rich story about your online behaviors. And metadata is basically data about data. So think about, again, think about in this context of sending a message online. The metadata will allow you to capture who sent the message, who received the message, when it was sent, what ISP it was sent from. So again, metadata really contains a really rich history of online activity and can be just as invasive as the collection of the actual content of a message. And often even this content is able to be sometimes reconstructed. So this is all a particularly interesting development. I'll say it's also a little concerning. For example, Edward Snowden was quoted calling the Investigatory Powers Act the most extreme surveillance in the history of Western democracy. This is particularly concerning when you think about who it comes from. Edward Snowden was the whistleblower who exposed the widespread surveillance program by the National Security Agency in the United States. So turning a bit more to the content of what the law does, the Investigatory Powers Act is a wide-ranging law that sets out how bodies in the UK can collect and handle data that may be linked to criminal activity. The law has added new controls to what law enforcement and intelligence agencies can do. For example, making it legal to hack phones, computers, and other systems. Again, as part of the changes, the creation and collection of internet connection records is something that's currently being tested at the moment. The tests actually, the orders for the first test came in July of 2019, with the second order followed in October of 2019. So the trials remain ongoing, and the Commissioner's Office says that this review is to ensure what the data types collected, to ensure that the data types collected remain necessary and proportionate. So you see some tie over to this language included in the GDPR, in particular, these guiding principles that are at least being paid well, they're being recognized at least in some capacity, even if it's just in writing. But that's speculation. Let's purport to take them for their word and remain diligent on what is going on. So a major issue being highlighted, of course, is this lack of transparency about what information is being collected, what's being required of these telecommunication services providers, and how this data is being used. This is all a really interesting and relevant discussion at the moment because this piece of legislation, the Investigatory Powers Act, is scheduled to be scrutinized next year as it requires a review 5 years and 6 months after the law was originally passed, that being November 2016. So it's definitely something to keep in mind, in particular, these tests and the creations of these internet connection records. It'll be interesting to see what limitations besides the requirement for a court order is placed on what type of data and what information is being collected and on who it's being collected. So turning from the Investigatory Powers Act and these trial test runs to create these internet connection records, I'd like to explore a bit about how Europe's intelligence services and the member states aim to avoid the decision of the Court of Justice of the European Union, in particular in relation to the outcomes of Schrems II and later cases that built on that precedent. So for a brief reminder, Schrems II was a decision of the Court of Justice of the European Union decided in July of 2020. The case invalidated the Privacy Shield, which was the transfer mechanism by which data could be transferred from the European Union to the US and vice versa. Part of the reasoning for the by the Court of Justice was that the surveillance apparatus and the national security operations in the United States were not necessary and proportional, and invalidated the privacy shield. And what resulted from that was a lot of criticism from the United States, in particular arguing that the Court of Justice held third countries to a higher standard in the areas of data collection for the purposes of national security than was required of the member states in Europe. Basically, here's a couple of quotes to summarize the position. The idea was that Schrems II created a double standard under which non-EU countries' direct access measures are subject to strict EU data protection rules, while comparable member states' direct access measures are not subject to EU law. So there was this strange paradox that national data protection authorities in Europe have no basis in EU law to sanction a company responding to an EU member state request for data on national security grounds, while they could heavily fine companies doing this and transferring data to the United States. So, yeah, there was this criticism of this double standard that is actually still ongoing, but it's not entirely accurate. So, in a couple of cases in the fall of 2020, the CJEU imposed limits on EU member states' intelligence services, data collection, and retention activities. In those cases, the names are La Quadrature du Net and others. The CJEU in particular tackled this question of whether and to what extent EU fundamental rights relating to data protection should limit European intelligence services data collection and retention programs. Again, this was a really interesting question, and 9 member states, including the UK, argued basically under 2 provisions, one under the Treaty on the European Union and one under the e-Privacy Directive, that that data collection for national security and surveillance purposes was left to the member states and outside the purview of the Court of Justice of the European Union. The court rejected these arguments, drawing in particular a distinction between the situation where an intelligence agency processes data itself for national security purposes and where it imposes an obligation on electronic communication service providers to collect, retain, and transfer that data on the state's behalf. So basically, the outcome was intelligence agencies can have direct access to data, but they can't require telecoms to do it. So this is kind of an important limitation, and one in which the member states have responded and are responding to. So in particular, as I mentioned, one of the provisions cited came from the e-Privacy Directive, Article 1.3, that and the quote is, "This directive shall not apply to activities concerning public security, defense, and state security." And so this directive, which governs electronic communications in the European Union, is currently in the process of being updated, and the e-privacy regulation, as it will be known, is being negotiated. Now, the member states led by France have included a prohibition on the CJEU's limitation in the new regulation. So it'd be really interesting to see if this provision survives. And if it does, it will undo these limitations, mild as they are, placed on the activities in the surveillance and national security realm by the CJEU. So yeah, it's a really, again, it's a really interesting thing to keep in mind. In particular, the debate in the privacy world seems to always weigh privacy against national security. And we see this debate playing out in the highest courts in Europe, as well as negotiations on new legislation. And it's definitely something to keep in mind and something to look out for as we go into this as we go into this next period, as the European Union adopts the and adopts the e-privacy regulation. Will it include this provision overturning the CJEU's limitations? Time will tell, and we will keep watching and keep you updated. Thanks for tuning in to the third installment of Soundbites, and I look forward to seeing you again soon. Thanks, bye.